One of the questions we get from time to time goes something like this: what is a self-proving affidavit for my will? Or do I need a self-proving affidavit for my will in Georgia? Hi, I'm Joel Beck with Peach State Wills and Trust, a division of the Beck Law Firm LLC in Lawrenceville, Georgia. And in today's short video, we'll answer that question. So, what is a self-proving affidavit? In a nutshell, it's an affidavit that is signed by the testator, that's the person who made a will, and the two witnesses who witnessed the testator signing the will. They signed this affidavit in front of a notary public, and then the notary notarizes it, signs his or her name, and puts their notarial seal on it. The self-proving affidavit states that the testator signed the will in the presence of the witnesses, declared that it was their will and executed it as a free act in deed, and asked the witnesses to sign the will as witnesses. And the witnesses affirm in this affidavit that they did all of that they watched the testator sign it, that they signed as witnesses, and that they're 14 years of age or older. Those are the requirements, generally speaking, for the self-proving affidavit under Georgia law. There's actually a specific code section in Georgia law that provides the template for this type of affidavit. So it's very easy to do and follow. But why do people do this? And what's the benefit or what's the downside of not doing it? Well, if you have a self-proving affidavit attached to your will, it means that the will is presumed to have been executed validly. It means it was signed and done, witnessed validly. And that means that we're going to eliminate the need to have to go round up the witnesses and bring them to the probate court after you die and have them testify that, yeah, he signed his will, she signed her will, and it was all done valid and in compliance with the law. Having that self-proving affidavit then helps make the probate process easier, because part of the probate process, the very first part, is we've got to prove up the will, show that it was executed validly so that it can be admitted to probate. And with the self-proving affidavit, we can eliminate that step. Now, some people have wills that are quite old and they don't have one of these. That does not mean that their will is not valid. Doesn't mean that at all. What it does mean is the will is still going to have to be proved. And that means that they're going to have to try to find the witnesses and have them testify or sign an affidavit that the will was validly executed at the time that it was. So, if you've got an old will, it still can be valid and be admitted to probate court once you die. But if it's possible, it might be a good idea to have a self-proving affidavit done. If you can get together with those witnesses and do that affidavit, dated as of current, and then sign the affidavit and attach it to the will. Now, if you've got more questions about wills or trust or estate planning in Georgia, I invite you to reach out and give us a call. We'd be happy to see if we could be of help. You can reach us at 678-344-5342. Or maybe you just want to get some information. We've got a wealth of information on our website at peachstatewills.com. Go there, look around, you're going to find some information, but you can also click on free info at the top of that page and get our free guide to estate planning in Georgia. That free guide is going to walk you through the 3 primary planning tools that we use for most adults in Georgia, and it's going to answer a lot of the frequently asked questions we receive. You can download that for free, no strings attached, at peachstatewills.com. Just click on free info at the top of the page. Thanks.